Hi, my name is George Palmer. I'm an attorney and I'd like to talk to you about small claims court. If you feel you are owed money because an individual or a business has treated you unfairly, you can certainly do something about it. I know all the legal jargon that bounces around in a civil or criminal courtroom can sound pretty confusing. The good news is that small claims court takes a much simpler approach. However, there are some things you'll need to know and consider before starting your lawsuit. In this program, I'll be talking to you about the basics of small claims court. We'll discuss how to start your lawsuit, how to prepare your case, discuss what to do before the hearing and during the hearing, and most importantly, we'll cover how the court can assist you in collecting your money after the hearing. Of course, small claims court isn't for every situation. This program is by no means designed to replace the advice of a personal attorney who can better guide you on your specific situation. Instead, this program is designed to increase your knowledge of small claims court and to provide you with information and guidelines when using small claims court as a legal resource. After we've covered the basics, you'll be able to effectively represent your case to the judge who, after hearing both sides of the case, will decide the outcome. Let's get started. Small claims court is a special court where disputes are resolved quickly and inexpensively. The rules are simple and informal. The person who is suing is called the plaintiff. The person who is being sued is called the defendant. The main purpose of small claims court is to give people access to court without them having to hire a lawyer. It's a fact that you do not need to know anything about the law in order to bring a suit in small claims court. However, there are some things you do need to know. Each state has a maximum amount for which you can sue an individual or a business in small claims court. Before you proceed with your lawsuit, you should determine what this amount is for your state by calling the small claims court in your area. If the amount you are seeking to recover exceeds your state's maximum that you can be sued for in a small claims court, you may want to sue in the civil division of the municipal court, or you may sue in small claims court and give up your right to the amount over your state's maximum claim. In the event you do seek a higher level court, I strongly recommend that you first consult with an attorney on how to best proceed with your lawsuit. Now, the rules in small claims court are very straightforward, and the costs of starting a claim are much lower than in the other higher level courts. But before filing your claim, you should have some idea what your chances are of collecting what you are owed. Remember, a judgment in your favor does not mean automatic payment. A judgment only means that you have proven to the satisfaction of the court that the person you have sued owes you money. There have been many cases where a judgment was not difficult to obtain, yet the collection of the money was very difficult, if not impossible. If you cannot collect a judgment in your favor, your win may actually turn out to be a loss. In small claims court, the case is heard by a judge. The proceedings are simple, with each side having the opportunity to explain its position, produce witnesses, and any relevant documentation that best presents its case. Therefore, adequate preparation for small claims court is crucial in order to help ensure a ruling in your favor. A person who sues in small claims court should first make a demand if possible. This means that you have asked the defendant to pay and the defendant has refused. If your claim is for the possession of property, you must ask the defendant to give you the property. Be sure you at least try to contact the other party and attempt to resolve the problem before filing a claim. If the person will not cooperate in settling the matter with you, it's time to file your lawsuit. To start your lawsuit, the first thing you must do is to file a claim against the person or business you want to sue. This must be done in person at a district court office. You must be at least 18 years old to file a claim. If you are not yet 18, you may ask the court to appoint a guardian ad litem. The guardian ad litem is usually a parent, a relative, or an adult friend. In order to properly file your claim, you must sue in a court that has jurisdiction over the matter. If you file your claim in the wrong court, the court will dismiss the claim. Although this is a complicated legal concept, the court having jurisdiction may be any of these: the place where the defendant lives or where the business involved is located, the location where the damage or accident happened, or the place where the contract was signed or carried out. Now, when you go to court to file your claim, be sure you bring the defendant's complete name and address. If the defendant is a business or a corporation and you do not know the exact legal name, check with the state or local licensing agency, the county clerk's office, or the office of the Secretary of State's Corporate Status Unit. If you do not use the defendant's exact legal name, the court may be able to correct the name on your claim at the hearing or after the judgment. If you want to sue a government agency, you must first file a claim with the agency before you can file a lawsuit in court. Generally, you must do this no later than 6 months after the act or event you are suing about. When you file your claim, be sure you bring copies of any documents that you have to prove your case, such as bills of sale, receipts, letters, photographs, accident reports, repair bills, or estimates. Promissory notes or contracts are also valuable. You will be asked to complete a claims form. Write down what your claim is about in a logical fashion. Try to steer clear of any emotional statements. Just stick to the facts and keep it short and simple. Remember to include any provable expenses or losses incurred because of what happened to you. The court will then deliver a copy of your claim to the defendant. As you cannot do this yourself, the person you are suing can be served in a number of ways: by the sheriff or marshal, a process server, or by certified mail. Again, make sure you know what fees are involved with serving your claim on the defendant. Once served with the lawsuit, the defendant will have to file a defense with the court. The court will send you a copy of the defense. Both you and the defendant will be notified of the date of your court appearance. This date is set by the court. Most hearing dates are set 4 to 6 weeks after filing a claim, and you should use this time to organize your presentation and your evidence. If you cannot go to court during working hours, ask the clerk if the court has trials at night or even on Saturdays. If you need to change your court date, you will need to request a continuance. A continuance is requested from the small claims clerk, but can only be granted by the judge. To request a continuance, the court may charge a fee. A continuance can be requested by mail by either party. A copy of the request is mailed to the other party. Requests should be made at least 10 days in advance of the court date. If the continuance is granted, the hearing will be postponed for at least 15 days. Notice of the new date will be mailed to all parties. If you don't have enough time before your court date to write for a continuance, you should either appear in court as scheduled and ask for a continuance, or bring a written statement explaining why you need a new court date to the small claims clerk's office. Ask to have it attached to your case file. There may be a small fee for this service. Now, sometimes the person who was sued, the defendant, will also have a claim against the person who filed the lawsuit, the plaintiff. This claim is called the defendant's counterclaim. The defendant may file this claim in the same lawsuit. This helps resolve all of the disagreements between the parties at the same time. Both claims will be heard by the same court at the same time by the same judge. The cost of filing a small claim is minimal, but the total cost will vary depending on the amount you are suing for, plus associated fees. Your main fee, of course, will be your filing claim fee, which will vary from state to state and will depend on the amount you are suing for. Other fees to consider include writ of garnishment or execution, discovery, subpoena, certified mail service, and personal service. In order to determine exactly how much the filing fee is, and if there will be any additional fees, look in the phone book under Courts and call to get specific information. You will need to bring cash or a certified check to pay the court fees, as most courts will not accept a personal check. Remember, if you win your case, you're entitled to be reimbursed for your filing costs. Be sure to request the award of costs in your claim. If you decide you need to change or amend a claim that has already been filed but has not yet been served, go to the small claims clerk's office and ask to have an amendment added to the claim. Be sure to bring your original claim forms with you. If any of your defendants have been served on the original claim, you will need to submit a letter to the court requesting permission to amend the original claim. To remove one or more of the defendants from your claim, use the dismissal form you received with your original claim. Be sure to indicate that you are dismissing the case only against one or more specific defendants, and that you are not dismissing the entire case against a particular defendant or defendants named in your original claim. Of course, it is possible that the defendant will offer to pay out of court once a notice of your pending lawsuit is received by them. If you reach such an agreement, make sure that the terms of payment are put in writing and are signed by both you and the defendant in the presence of a witness, preferably a notary public. You will then need to file a copy of this agreement with the court. Once this has been accepted by the court, the agreement becomes an official judgment of the court and is enforceable by law. On the other hand, if the defendant does not offer to settle out of court or request that the case be heard in a higher court, you should begin preparations for the small claims court hearing. Remember, once in front of the judge, you will want to present all the relevant facts and information clearly and concisely. I would recommend that you outline the major points you wish to make beforehand. Then go over your presentation, making sure you have gathered together all the supporting documentation you'll need in order to effectively present your case to the judge. You should also contact witnesses that you will want to appear in court on your behalf to support your claim. If you plan to use signed statements or copies of documents in court without the person who wrote them there, you must give the defendant that person's name and address, along with copies of the statements and documents at least 2 weeks prior to the trial date. If there is a witness who you think might not come to court unless they are required to, both you and the defendant can require witnesses to come to court by having them subpoenaed. Ask the small claims court clerk in your area about how this procedure is conducted, who will serve the subpoena, and if there is a fee for this service. You can also prepare for your trial by going to small claims court beforehand to listen how other people present their cases and what happens in court. This will give you a good idea of what to expect. Also, people who do not speak English or who are deaf may bring a family member or a friend to court to interpret for them. Many courts have a list of interpreters who will interpret for you. Some interpreters are free and some may charge a fee. If an interpreter is not available, the court must postpone the hearing one time so that you might have time to get one. The hearing will usually take place at the court where you filed your claim, unless another location is specified by the court. Be sure you know exactly where you will be going, and above all else, be there on time. If you fail to attend the hearing without having notified the court, your claim will be dismissed. If the defendant does not show up for the hearing, the court will usually grant you a default judgment. This means that the judge decides in your favor even though the other side of the case has not been presented. If both parties do show up, the hearing will proceed. The court clerk will call your case when it's time for the hearing, and then you and the defendant will appear before the judge. The judge will ask you to state your claim. Tell your story with the facts just as you filed them in your original claim, clearly, concisely, and in a logical, non-emotional fashion. Tell the judge why you think the defendant owes you money and what you would like done. Again, I must stress, this is not the time to vent your anger and frustration. It is important that you respect the court and do not exchange any remarks with the defendant. Stick to the facts and state your testimony clearly. Show the judge any documents or other evidence you have that best presents your case. Introduce any witnesses you might have to verify your claim. The witnesses will be allowed to tell the judge what they know about the case in their own words. You can also ask the witness specific questions relating to your case. It's a good idea to prepare your questions ahead of time and talk to your witnesses before the trial so that you know what their answers are likely to be. The defendant may also ask your witnesses questions. After you have told the court your side of the story, it will be the defendant's turn. The defendant will try to persuade the judge that you are wrong. You may want to take notes on what the defendant and the defendant's witnesses say. You have an opportunity to ask them questions to try to clarify or discredit their stories. Your questions can be about anything relevant to the facts and issues of the case, or anything specific that might challenge their credibility. If you think the defendant is leaving something out or changing the facts, raise your hand and tell the judge in a respectful and non-emotional way. The judge will want to hear all the facts before making a decision. The judge can either reject your claim or order the defendant to pay all or part of it. He can also order the defendant to pay other costs, such as any fees you may have incurred during your lawsuit. Of course, if the judge feels that your lawsuit was unnecessary, you may have to pay some of the defendant's costs. But let's assume the judge rules in your favor. Provided the defendant does not appeal, it's now time to collect your money. Once the judge decides in your favor, you become the judgment creditor, and the defendant becomes the judgment debtor. The defendant must pay you the amount ordered by the judge. This usually includes court costs. Enforcement of the judgment is postponed until after the time for any appeal has ended or until after the appeal is decided. In other words, the judgment creditor cannot collect any money or take any action to collect their money until after this period is over. More information about your rights is available with the Notice of Entry of Judgment form, which both parties will receive after the judge's decision in the lawsuit. If no appeal is entered by the judgment debtor, and if they refuse to abide by the order of the court, there are legal options available to you to help you collect your money. First of all, ask the court how it can assist you in collecting your money. For a small fee, the court may be able to issue a writ of garnishment. This means that the judgment debtor must make payments directly to you from their wages or bank account until the amount has been satisfied. Income such as welfare, unemployment, or Social Security cannot be garnished. If the court is unable to carry out a garnishment, it might choose to issue a writ of execution. No, this doesn't mean that the judgment debtor will be shot at sunrise if he doesn't pay up. It simply means that the court could seize some of their property, such as real estate, automobiles, stocks, bonds, and then sell the property in order to satisfy your judgment. In some courts, this is also known as an abstract of judgment. In many states, if you have obtained a writ of execution from the court, you can have the sheriff do a till tap. If the debtor is a business with a cash register, the sheriff can go to the business and take enough money out of the register to pay the judgment, and also his fee. If there is not enough money in the register to pay the judgment, you will have to pay another fee each time the sheriff goes back. Another collection method that can be used in accordance with a writ of execution is to put a keeper in the debtor's business. If the debtor is a business, the sheriff will, for a fee, remain in the debtor's business, including a doctor or dentist's office, and take all the funds that come in until the judgment is paid. The keeper can collect cash, checks, and bank card drafts. Be sure the sheriff has the name and address of the business. Again, you will have to pay a fee to the sheriff each time he goes back. You may also elect to hold a judgment debtor hearing. This requires the debtor to come to court and answer your very specific questions about his salary, bank accounts, property, and anything else that could be used to pay the judgment. To initiate this type of hearing, ask the clerk of small claims for an order to appear for examination form. There is a fee. The order to appear for examination must be served by the sheriff or a registered process server, and, generally, the debtor must live within 150 miles of the court. If you wish, you can subpoena bank books, property deeds, paycheck stubs, etc. before the hearing. You will need a subpoena ducis tecum. This subpoena can be obtained from the clerk of court as well. In some states, if you have won a judgment of $500 or less in an auto accident case, and the judgment is not paid within 90 days after the judgment becomes final, you can have the debtor's driver's license suspended for 90 days. Ask your state's Department of Motor Vehicles for more information and the proper form. There is a fee. Once the defendant has complied with the judge's decision, you will be finished with your small claims lawsuit. But what do you do if you suddenly find yourself as the defendant in a small claims suit. If you are sued by an individual or a business, you become the defendant. It is up to you to file a claim of defendant. If you feel the person suing you owes you money, include this in your countersuit. Both cases will be heard at the same time. If you are served with a default of judgment, this means that the court has ruled that you owe money to a person or business who has sued you, even though you were not in court to tell your side of the case. If your reason for not going to court was because you were never served with a copy of the claim, you have a period of time, usually 180 days after you were served, to file a notice of motion to vacate judgment. You cannot appeal the original default of a judgment and have a new trial until you vacate the default judgment by filing your notice of motion to vacate judgment. This is the only way you can have the judgment removed or erased. Be sure to determine the exact period of time you have in your state after an initial judgment has been made for filing your notice of motion to vacate the judgment. Now, to officially vacate a default of judgment, you must do the following. Get the form notice of motion to vacate judgment from the small claims clerk and fill out the form and file it with the small claims clerk together with the appropriate filing fee. You must do this within 30 days of the date printed on the entry of judgment notice by the small claims court clerk. When you file the form, the small claims clerk will set a date on which you and the person suing you are to appear in court. The judge will decide to vacate the judgment against you or not. Oh, and by the way, you should have a good reason for not having appeared in court when you were supposed to. In order to help the judge decide in your favor, be sure to bring whatever evidence you can to the hearing to show why you were unable to come to the court in the first place. An example of what to bring might be a letter from a doctor or a hospital bill. If the judge agrees to vacate the judgment, the original case will probably be heard right then. Be prepared to tell your side of the story and present your evidence in an organized and concise fashion at that time. If you have witnesses to help your case who could not be present, you can ask the judge for a continuance. If the judge decides not to vacate the judgment, you can only appeal the judge's denial of the motion to vacate. You cannot appeal the actual judgment against you. You must file the appeal within 10 days of the judge's decision. To file the appeal, get a form called Notice of Filing Notice of Appeal from the small claims clerk. Fill it out and file it with the small claims clerk with the appropriate fee. If the judge decides not to grant your appeal and not to vacate the judgment, you are responsible for paying the judgment. In small claims court, the case is heard by a judge. However, if all parties are in consent, the case can be heard by an arbitrator. Most states have an arbitration organization that can be found in the phone book. The arbitration organization in your area should be contacted for specifics if you feel this might be an option you want to pursue. As in small claims court, an arbitration hearing is informal and is not held in a courtroom. You must understand that the arbitrator's decision may or may not be binding, depending on what the parties agree. Proceedings are simple, as in small claims court, with each side having the opportunity to explain its position, present witnesses on their behalf, and produce documentation that supports their case. Your state may also have a court dispute referral center, which provides information and referrals to mediators who can help you reach a mutual agreement without pursuing litigation. I hope this program has given you some valuable insight and has helped you in preparing for small claims court. And while I have tried to cover most of the common procedures associated with small claims court, remember that no single reference source can possibly cover every circumstance or detail on this or any other legal subject. After you have gathered all your information and put together a framework for your small claims court case, if you have further questions or if you feel the circumstances surrounding your case are more complicated than cases typically presented in small claims court, I strongly recommend that you consult with an attorney for more advice. If you don't have an attorney, check your local yellow pages under attorneys or ask your friends or neighbors for a recommendation. Then, make an appointment to talk it over with a professional. And remember, the more prepared you are when you do present your case, the better your chances are of winning in small claims court.